A guardian ad litem serves as an important position of representation in family court cases, acting as a neutral advocate for the children.
But for attorneys and families who have to work with these individuals firsthand, they say guardians ad litem, known as GALs, hold unchecked power and little accountability. Live 5's investigative reporter Emily Johnson tells us about some problematic guardians who are slipping through the cracks. She explains how proposed legislation hopes to hold them more responsible.
Inside of a family courtroom, mothers and fathers are often fighting for custody of their children. And in the middle of that fight is a guardian ad litem, a third-party individual who is appointed by a judge to essentially be the eyes and ears of the court, helping to determine the best interest of a child.
I do know some really wonderful lay guardians, but a lot of the times the lay guardians are not very equipped for the position. And that's a dangerous thing and a scary thing, because we're talking about a case involving custody.
There are two types of GALs. A private guardian ad litem, who is often an attorney, and a volunteer guardian ad litem, or otherwise known as a lay GAL. A private GAL must graduate from law school or must meet certification and training requirements by South Carolina's court administration. As for a volunteer GAL, you must complete a 30-hour online course, have a high school diploma, and pass a background check.
People who want to be a lay guardian, I think, have their hearts in the right place, but the issue is the training is not there. The training is bare minimum. I mean, I think it's harder to get your driver's license than it is to become a lay guardian. Again, a 30-hour class that can be virtual with no requirement for an exit exam to pass basic questions is, I think, concerning and an issue.
Both kinds of GALs visit the homes of the cases they're involved in to make sure a child has a safe environment. They fill out a report, simply checking a box if a child was alone or not, and detailing how the children appeared before presenting their findings to a judge. When presenting findings, either kind of GAL can make recommendations before the court.
They need to take all that information and they need to deliver it to the court, but they do not need to tell the court what they feel is better. Either the dad should get it, the children, or the mom should get the children, because the judges are the ones we've placed in that position for that reason. But it happens routinely.
State Representative and attorney Gil Gatch says he's seen GALs time and time again reach beyond their scope.
I have seen where a guardian ad litem, lawyer or non-lawyer, will tell a therapist how to do their job. I have seen a guardian ad litem secretly record a client.
But the impact of dealing with an unqualified GAL can not only be exhausting, but some say it can change the trajectory of children's lives.
And he was 22 days when they took him. So they missed his first haircut, they missed his first words, his first steps. I mean, they missed all the milestones of their kid's life, because, the guardian was unwilling to say, hey, wait a minute, maybe there's another reasonable example for this.
Lawana Bell is a mother of two and went through South Carolina Family Court starting back in 2023. She was appointed a private GAL by the court.
She took the best thing out my life, God, and now she's running around here like she's just so superior and she cannot be touched, Lord. And this is wrong.
The GAL on her case was convicted of assault in Ohio 36 years before, according to court records. South Carolina law states a person may not be appointed to serve as a GAL if they have a criminal record indicating behavior that would pose a significant risk of harm to children or others.
So now this lady got all these charges, and they letting her be a person in the courtroom to tell them about best interests of a child.
In a different case, the same year as Bell's, a judge found the same GAL disqualified because of her Ohio offense. The GAL told Live 5 her Ohio conviction has since been expunged, and she still continues to act as a GAL in family court cases. But this still prompts the question of why someone with a criminal record at the time is qualified to work as a GAL.
How are you going to take care of my kids when you have criminal charges? I really think the state do not need to give guardian ad litem power. They give them too much power.
And Bell was put behind bars twice because she could not afford the fees required to keep paying for her court-appointed GAL.
If I'm paying my bills, no help, and taking care of my kids, I don't care about that. You're supposed to pay her. I was scared. I was so scared.
And if you don't pay the guardian ad litem, you go to jail. So it's a lot of pressure.
So how can gals, both private and volunteer, be held more accountable? Gatch has filed multiple bills in the State House specifically addressing changes needed in the Guardian Ad Litem system.
Those bills really point to a single overarching theme: the concern that there isn't any accountability to misconduct with Guardian Ad Litems in family court cases.
Some main points proposed in the bills include prohibiting gals from making recommendations to the court, gals being subject to investigation for certain misconducts, and requiring gals to be licensed attorneys, limiting lay volunteers to cases without representation.
Judges give Guardian Ad Litem too much rights. Guardian Ad Litem have more rights than DSS has.
Until the next legislative session begins in January, families say they hope people with the best interests of a child at heart will continue to serve in the family court system. For Live 5 Investigates, I'm Emily Johnson.
The individual gal referenced in the story was not specifically named due to the status of her Ohio charges as of the date of this story. Her attorney provided a statement that reads in part, she is now fully compliant with South Carolina statutes, is eligible to be appointed as a gal in all family court cases, and has been appointed regularly and consistently by the South Carolina Family Court since that time. She is proud to serve our courts and to represent and serve our children, our most important and vulnerable citizens.